I welcome all of you who managed to make it today, and I want to encourage us to make it a success, because success begins at Cavendish. My name is Godfrey Airanga. I am a law lecturer at the Faculty of Law at Cavendish University, Uganda. I am also the Moot Court coordinator, or what others refer to as the Moot Coach of this beloved university. I'll start this presentation by telling you what is a Moot Court. Mooting is a process through which we train our law students and expose them to the court life. So in a moot court, we give students a scenario of a moot problem, which is fictitious, and so they are supposed to look at that case study, draft arguments as if they are lawyers representing certain parties. For example, you could be representing a plaintiff, a defendant, an applicant, a respondent, so that now when they come to the moot competition, they are able to act and simulate as if you are in actual court. So for example, you'll find you have judges who could be lecturers, fellow students. You then have two students, one arguing for an applicant, another arguing for the respondent, and then you could be having other people now watching as the session is going on.
All of you sitting right here today as women, I want you to understand one thing. That is, in Cavendish, there is no discrimination when it comes to mooting. Whether you are a male or a female student, we are all equal here. Mooting is about how best you interact with the judge and how best you answer the judge's questions. That's all. Even if you're able to just say half of a page, but make sure you answer their questions, you will find your way out.
Through these moot courts, we can be able to make you better lawyers. Secondly, in the moot courts, we get for you imaginary facts. We place you in the field as a young law student, and we put you in the shoes of a lawyer, and we give you a side to defend. We can make you the applicant or the respondent, so that you start thinking as a lawyer.
I remember in my first moot, I knew nothing about the law. One, I was very nervous when it came to speaking in front of people. I may look like someone who's always chatty, but my first rounds were very scary. I was shaking, and I can tell you that now I'm much more confident. I can speak in front of people. My research skills are better. So those are some of the benefits of being a mooter.
Mooting, be it external, be it internal, it is the one guaranteed thing that will actually give you the necessary experience in relation to legal research and legal writing. You get to learn about particular rights that are not necessarily taught in classroom. It helps you develop your advocacy skills. I've mooted on an international level. I have been before the Ugandan court, I have been before the African court, and I've been before the ICC, the International Criminal Court. The Christoph Haynes African Moot Court competition gives you benefits. For instance, you participate in that moot court competition, you have a guaranteed slot to go and study LLM from Pretoria or any top-notch universities in South Africa. Finally, it will give you the practical experience.
Now, I'm here to tell you about those things that you can do to make sure that mooting and legal drafting or legal research is not stressful and is streamlined. If you cannot read your moot problem like this, you're not reading a moot problem. Are you underlining the key points in the moot problem? Or you just read the moot problem and then later when you come to making research, you cannot even relate back and fall back to the points that you read. Remember, when you're reading this moot problem, every single concept in there is important. Be it a number, be it a year, that timeline. They're very critical to how you finally do research, how you finally arrive at the arguments that you need mostly. When you're also reading the moot problem, take some time off and jot down the key legal terms. What do I not understand? The key legal terms that you don't understand, the key legal terms that you understand, because they're all going to be very, very relevant in your research. Then lastly, understand the competition rules. And then the most important thing that most students do not know is following lead. In research, following lead is very critical. How do you follow leads? I've asked the first question, what is human trafficking? But human trafficking is going to give me a certain definition which is not satisfactory, and I need to follow that lead to first understand that point that was not very specific or satisfactory for me. So you follow that lead.
I'm going to talk about the technicalities of legal research. Legal research, as he has told you, it's the art of actually finding out what the judge wants and bringing it onto the table. Now that question is usually a hard question to answer. The legal principle is basically what area of law are we looking at? Now we move on to what we call secondary sources. Now secondary sources are sources that explain a different legal principle. Now secondary sources include textbooks, legal dictionaries, online sources. When you get to know all these secondary sources and perspectives of different people about the area of law you are going to deal with, it makes you understand what the law is expected to achieve. Then after that, we move on to the primary sources. Now, primary sources, these are legislations or laws. Primary sources are where we do not have a debate. Primary sources are usually enshrined and get their fundamentality from the Constitution. In Uganda, that's Article 79, Clause 1. You need to know the jurisdiction in which you are and what are the binding laws within that jurisdiction. So as long as you have that checklist, in an hour's time, you can handle any problem question and finish it.
I've been tasked to talk about drafting legal arguments. A legal argument is the substance of the reasons for the claim before court. Why are you here? It is that which is presented or submitted to court before the oral rounds, before the oral presentations. So it is marked out of impression. Number one, it must have a cover page. It will also highlight which party is making the presentation, which party is authoring the submissions, the memorial. So you will also have a space where you put memorial for the applicant, memorial for the petitioner, memorial for the respondent. 2, table of contents. That is the next thing. Item number 3 for the memorial is a table of abbreviations or a list of abbreviations, really. Number 5 is a summary of facts. How are you intending to answer the question? Are you intending to answer it in the affirmative or in the negative? Are you submitting that the state failed in its obligation maybe to do this? Or you are submitting that the state did not fail, and thereby you are the Attorney General representing the country. Lastly is the conclusion. And by the conclusion, we mean the prayers. Why are you before court? Or what are you requesting court to do for you? If you read the facts, what comes to your mind if you are going to present something? What comes to your mind? Can you yourself stand on what you are saying? You actually believe in what you are saying. So while drafting a legal argument, you must be very sure of the laws that you are going to be relying on the precedents you are going to be relying on the cases you are going to be relying on, and also your analysis. When you are making an argument, you should also be sure that the argument I'm making can defeat the other side. Because also at the same time, you must make an argument knowing the way you can go around it when you're on the other side.
My name is Edwin Sabit, as introduced, and I'm a fourth year law student in my final semester at Makerere. I was specifically invited today to talk about the challenges and how you can navigate the challenges that you may face in your mooting career. When you go for competitions, don't look at it as though you can't interact with whoever you're going against and all that. You should create friends. Get your reading list, look at it, and set goals on that reading list and say, before today ends, I should have read this number of cases. Secondly, you should make use of your friends that otherwise are not taking part in moots. So sometimes you find that you won't be able to attend certain classes. What you have to do is try to talk to friends. So you can encourage some to type the notes, or you can find those that have beautiful handwritings, such that they take down the notes, reach out to lecturers where it's possible, and let them know about your special predicaments that you might be having, especially when you are facing a challenge with balancing academics and moots. That's all I had to share. Thank you very much.
Stage fright, maybe Mimi can say something about it, but all the things that I can say about stage fright, it all goes out with preparation. When you prepare, like Edwin was telling us, when you prepare, you get that kind of confidence that I know what I'm talking about because you are prepared.
You heard Edwin talk about how you can practice in front of your mirror. I do that all the time. I talk to myself like I'm a mad lady, but if you're going to moot, the one thing that I think scares me is going up before a judge and not knowing what you're going to say. Because they will put you under pressure and your entire submission will go out the door. So the one thing I can say is always be prepared. Know what you're going to say before your judge. And if you can, have a roadmap. Go up there at least with one sheet of paper and have your points written down, that when you feel that you're going off topic, you can go back and refer to it, because it will keep you on track so that you have a correlation and a chronological order of what you're going to say.
Another point we'll have to talk about is decorum of court.
Okay, the one thing that you should always go into the moot is know which court you're going before and know how to address the judges, because you have to have a certain level of respect for them. The one thing that you study the judges, know who they are, know how you're going to address them. If it's the High Court, my lord. And one thing that I think always throws people off is that when they get up there, they want to submit and finish. But you're always going to have a judge who will stop you. And it's always in your mind that you should just keep speaking. But whenever a judge speaks to you or addresses you and says, counsel, pause, stop, even if you were in the middle of a sentence, listen to what they have to say to you, because they're on the bench for a reason. They've got there and they need their respect.
It's very important, of course, to know which court you are before and how you address whether my lord or excellency. And please, you ought to repeat that, but not many times that it becomes very irrelevant. The issue, why you have to keep decorum is because some of these judges are really tough. And the moment you show them that you know it all and you're not being very respectable, they will put you to a place whereby they will irritate you. Summary of facts.
So the one thing that you need to remember is that you're either going as an applicant or respondent. So I think if you're applicant, look at the facts. What do the facts say? How do they support your case? And don't take, obviously you have to read the facts and know your facts from beginning to the end. But take the facts that make your case, that sell your case to the judge. Because remember, applicant and respondent both have something they can submit on. And I think another thing that you should always do is know where to find your facts. They always say a good lawyer knows where to find the law, but also know where to find your facts. If you're submitting and you say your facts are on page 5, paragraph 3, make sure you constantly refer the judge to where those facts are, pinpoint them, but also know them, because they'll ask you questions, and once you know them in your head, you won't have to go back and start looking for and flipping pages.
In regards to conceding, you have to be very careful because it might be a trap. The judge can ask you, counsel, do you concede? Or you might actually state it affirmative that counsel concede. Be careful, don't be quick, don't be intimidated. And then you say, because some moments when you concede, you're done, the case is done. So be very argumentative, but please have reasons why you're taking that stand, and make it, of course, make it reasonable.
I would like to thank Tanya Innovations for giving me the platform as a young lawyer and a learning counsel to advocate and to inspire us to keep mooting and giving us the platform.
I must appreciate Tanya Innovations again for the collaboration with Cavendish University and giving us this platform to showcase what we have, what the products of Cavendish University are capable to do. And also I would like to tell everybody else outside there that it does not matter much what people say. It matters much what you believe in.
I would like to thank Tanya Innovations Africa for partnering with Cavendish University Uganda, because that way we are given a platform to actually share a lot of ideas that affect our society through the law perspective.
I really want to thank Tanya Innovations, as it has always done, coordinating and supporting students' activities to ensure that the youths are able to develop. So we truly appreciate the management of Tanya Innovations for such initiatives to see how best we can improve the students' culture, the learning environment that is conducive. We really appreciate them. But also, I also want to thank the administration of this great university that has always ensured that whenever we have these competitions, they come through. They give us funding, they give us resources when it is required, and sometimes just being able to allow us to participate is very encouraging. But I also want to encourage my students that they must, and the whole world out there, to know that these wins or these victories are not done or achieved one day. It's a process. And so when you lose one competition, you keep going. And so it's important for everyone in life to continue improving and never to give up. But finally, never to forget who God is to you.